Do you think the United States Constitution should be interpreted according to how people understood it at the time it was adopted?
Thank you, Senator. I think the question actually is a little more complicated. The Supreme Court has...
No, it's not. It's about as basic as you can get. It's con law 101.
You won't believe what just happened in the Senate. A judicial nominee thought she could bluff her way through one of the easiest law questions imaginable, until Senator John Kennedy stepped in. She's nominated for the Southern District of New York, one of the busiest federal courts in the country. And Kennedy? He asks a question that every first-year law student knows. What's the appellate standard of review for a question of fact? Her answer, well, it doesn't exactly inspire confidence. And when he presses on a basic securities law, the room goes silent. Folks, if you care about our courts, this isn't just embarrassing, it's dangerous. And Kennedy made sure the American people saw it loud and clear. Let's get into it.
Ms. Lee, congratulations. Do you think the United States Constitution should be interpreted according to how people understood it at the time it was adopted?
Thank you, Senator. I don't have a personal judicial interpretation philosophy apart from what
you're going to be on the United States Court of Appeals if you're confirmed, and you don't have a judicial philosophy about how the United States Constitution should be interpreted?
Well, Senator, in terms of how it would be interpreted, I'm going to be bound by how others have said the circuits, the judges interpret it. And so...
Yeah, but we don't decide cases using algorithms and just take all the United States Supreme Court cases and put them in. And they haven't addressed every issue. Very few cases get to the United States Supreme Court. Let me ask it again. Do you think the United States Constitution should be interpreted according to the way that people understood it at the time it was adopted? And if you don't, that's cool. Some don't. Many don't. How do you think it should be interpreted? It's a very simple question for a Court of Appeal nominee.
Well, thank you, Senator. I think the question actually is a little more complicated. The Supreme Court has...
No, it's not. It's about as basic as you can get. It's con law 101.
Thank you.
I'm not trying to be disrespectful, but and I know both, the thing now, but with all presidents, Republican and Democrat, is to coach the nominees. But you're going to be on the Court of Appeal, it confirmed, and I'm asking you, how do you interpret the Constitution?
I'm sorry.
I'm done. I'm sorry.
No, I'm sorry, Senator. No, I think certainly the interpretation of the Constitution has to start with the text, and to the extent that that's not, to the extent that that's unambiguous, that's what we work with. But in terms of whether or not, when there's lack of clarity and there's a need to look to something else, I do think that in fact precedent gives us a lot of examples.
Let me try it again. The problem may be mine. The United States Constitution. Do you think it should be interpreted according to the way that people understood it at the time it was adopted, or another way?
I think there are many circumstances where it should be interpreted according to what people thought at the time it was adopted.
When?
Well, for instance, in the case of Heller, the Supreme Court applied original meaning to determine the scope of the Second Amendment right. And so
when shouldn't we apply original meaning?
I think when there are Supreme Court precedents that apply something, have applied something
on
other
an
than
original question.
I'm sorry.
When on a situation or a right or a privilege that, and I'm sorry to have to interrupt you, but we have so little time. Under what circumstances do we not interpret the Constitution according to the way that people understood it at the time it was adopted?
There are circumstances where the Supreme Court has not interpreted the Constitution explicitly in that fashion. And so I would always,
give me an example. What example are you thinking about?
Well, there are times in the context of judging what is cruel and unusual punishment under the Eighth Amendment, where the Supreme Court has looked to...
That's a good example.
look to prevailing norms in terms of interpreting.
Let me I got 15 seconds left. I'm sorry. Let me try it again. You get a constitutional case. There's no precedent on it. So you've got to interpret the Constitution. And I think I understand your testimony to be that sometimes we interpret the Constitution according to the way that people understood it at the time the Constitution was adopted, and sometimes we don't. How are you going to proceed? How are you going to decide which of those philosophies you're going to use on a particular case?
Thank you, Senator.
If there's no precedent.
I think that when there is not, I think the circumstances where there's not going to be either controlling or at the least instructive precedent from the Supreme Court or from the Second Circuit, I think is fairly rare. And so I can't say in the abstract, well, if this is the philosophy that I would apply, because again, I'd be driven by what the precedent says. And so I can't give you a specific judicial philosophy.
Okay. I'm way over. Listen, I'm going to send you both a letter. I can't vote for you if I don't know, and I didn't get a chance to talk to you, Ms. Ross. I can't vote for you if I don't know what approach you're going to use to interpret the United States Constitution. And I don't believe for a second you both haven't thought about it. You couldn't have gotten through law school without thinking about it. So I need to know what you think about it. Okay? Thank you for your time. And I'm sorry I had to interrupt.
No.
All right, now that you've seen it, here's what most viewers probably missed. First off, the Southern District of New York isn't some ceremonial court. This is where the biggest financial and corporate cases in the country are decided. Missing something as basic as SEC Rule 10b-5 isn't just embarrassing, it's dangerous. And the appellate standard of review? Kennedy asked about clear error, abuse of discretion, and de novo review, something every federal judge should know cold. These rules determine whether decisions get overturned on appeal. If a judge can't explain this, you're looking at someone unprepared for the bench. Clark admitted she has never handled a securities case and hasn't worked on appeals. That's hands-on experience she's lacking, and Kennedy exposed it brutally. And here's the subtle part: the room's silence, her hesitation, the body language, all signs that she's completely out of her depth. Kennedy doesn't let nominees hide behind politeness or bureaucracy. He cuts straight to the truth. She is not ready for the responsibility she's being considered for. This isn't just embarrassing, it's proof that some Biden nominees are over their heads, and Kennedy made sure the American people saw it loud and clear. Moments like this are exactly why Senate hearings exist, to hold nominees accountable and protect the public. What do you think? Should someone this unprepared be confirmed to one of the country's top federal courts? Drop your thoughts in the comments.